Hello friends, in the series on the income tax cases, today we will discuss a very important case and in fact very interesting, where the notice under section 148 was issued on the same issue for which the proceedings under section 148 was already going on and the assessment was already going on, and a fresh notice to the assessee was issued on the same issue. So the question before the Honorable Bombay High Court was that whether the second notice issued on the same issue under section 148 is liable to be quashed in the writ petition. This issue has been taken up by Honorable Bombay High Court in the case of Samiksha Gour versus Income Tax Officer and others. This case is reported in 478 ITR at page number 187 and the date of the judgment is 22nd April 2024. The facts of the case are really very interesting, which is a classic example of total misapplication of mind by the learned assessing officer and by the learned approving authority for issuing the notice under section 148. The assessee was a non-filer. He has not filed the return of income for the assessment year 16-17. The assessee has entered into some shade transactions. The revenue got the information that the assessee has dealt in so-called penny scripts. The notice under section 148 was issued in the old regime to the assessee on 14th June 2021. After that, the proceedings under section 148A clause B were initiated against the assessee in pursuance to the Ashish Agarwal case, and accordingly the 148 notice was issued on 29th July 2022, and in consequence to that the assessment order was passed on 22nd May 2023. The assessment was already completed on 22nd May 2023 by making the addition for which the assessee was in appeal. The interesting thing in the present case arises the moment when the assessing officer issued a fresh notice under section 148A clause B on 2nd March 2023, that is before the assessment is completed under section 147 on the earlier notice issued under section 148. And in the second notice, the logic for issuing the notice was that the information was on the inside portal naming an entity MIFL as advised, meaning thereby that MIFL company was advising or suggesting that the income of the assessee has escaped assessment. Only on that basis the notice was issued. The assessee could not reply to the second section 148A clause B, and accordingly the order under section 148A clause D and notice under section 148 was issued, and again the assessing officer made a very blatant mistake that in the order under section 148A clause D there were two items included which were not there in the earlier notice under section 148A clause B. The assessee challenged this notice in the writ petition by saying that this notice is bad in law because the same matter is already in the appeal. The approving authority has given his mechanical approval when the matter was heard by the Honorable Bombay High Court. The court was of the view that in spite of that the matter was already in the appeal, this notice is liable to be quashed because the assessing officer has not even bothered to go to the portal of the assessee and to examine that the same matter is already being added into the income of the assessee for which the appeal is for which the assessee is in the appeal, and the assessee was not even show caused for the items which has been there in section 148A clause D order because they were not included in the notice under section 148A clause B. Friends, this is very unfortunate that this is the quality of the notices which are being sent and which are being approved by the approving authorities, because this is the classic case where it can be said that the assessee is being harassed by the process of issuing the notices under section 148, because if the assessee has not challenged this second notice, then there is no doubt that the assessing officer has made again the same addition which has done in the earlier section 147 proceedings. So in the present case, the court has no hesitation in questioning the second assessment proceedings. At the end of this video, once again I am repeating the name of the case. The name of the case is Samiksha Gour versus Income Tax Officer and others, and this case is reported in 478 ITR at page number 187, and the date of the judgment is 22nd April 2024. Thank you, friends.